I still see your desktop. Zoom is doing it again, huh?
How about now?
You got it.
Take it away,
Perfect
Roger.
mode. Good to go.
Okay, as always, this is not legal advice. This is just information. I'm a lawyer, not your lawyer, but I'm going to go through a handful of tax issues relevant to startup companies. This is super high level. And every month we do this, and I kind of review my slides ahead of time, and I fix typos and tweak this and that. I got to tell you, this morning I was reading them and I was just adding slide after slide after slide because this is such a big topic. There's so much to talk about. Um, and that's why don't freak out if I don't get through all the slides that I have here today, because I promise you I will not, but I am going to make them available. I'll email them to you if you want them. They'll be on SlideShare, and always you can find this whole thing on YouTube, including that awesome introduction from Bob. Now, a lot of what I'm talking about here today, I first heard about almost 50 years ago, and when I was in school. And I've been working with some of these concepts, and they haven't changed. The concepts have not changed in 50 years. Some of the rules have changed a little bit, and we're going to go through that. But this is not meant to be a trivia test. We're really more focused on the content. You should see a slide that says summary, and I assume you do. Okay, we're going to go through startup tax generally. We're going to focus on intellectual property, compensation, and these last three categories really have to do with gains on sale. So let's jump right into it. So kind of the number one biggest thing to know about startup tax is something we talked about before, Section 351 of the code. And this is the idea that you can incorporate a company tax-free. Because if you think about it, the our federal tax code, it taxes income from whatever source derived, and that's any gain. So, for example, if without Section 351, if I were to take this intellectual property I created and put it into this corporation that I formed, I assign it, we all sign those invention assignments, and I get back stock, that would be a taxable exchange, right? It's just the same as if I traded it for IBM stock. But 351 protects us. And what 351 says is that there's no gain or loss recognized if property, number one, property is transferred to, well, it's got to be a corporation by one or more persons solely in exchange for stock. And after that exchange, the transferors are in control, meaning owning 80% or more of the company. So let's drill down on a couple of these because it's a simple rule that everybody takes for granted, but sometimes you can blow it. So it does require sometimes a little bit of attention. First of all, it's control. So the transferors as a group immediately after the exchange have to own at least 80% of the vote and value. Now, where this comes up as a practical matter is A and B form a company and they each get 50% of the stock in exchange for their property. Okay, together they have 100%. That's more than 80. They have control. No gain or loss on the formation. That's awesome. Then a year later, party C comes along and says, I'd like to be a founder too. And I have some IP I want to contribute. So now founder C puts money in and they get 30% of the company or 33% of the company, we'll say. Well, the transferor in that case does not have control after the transfer, and that's a taxable transaction. So that's really the practical issue that comes up that we need to deal with. And of course, there are a lot of ways to deal with that because we just have to have a plan pursuant to which the stock is issued in order to meet this requirement. The second issue that comes up in this space is around this definition of property, because at least here where I practice in Silicon Valley, we take a pretty broad, expansive view of what constitutes property. And in fact, the cases have been pretty lenient. If you read them, in one case, a letter of intent was deemed to be property, and even non-exclusive patent rights under one case. But generally, what we worry about is this property or is it a mere license right, which does not rise to the level of property? And this is one of those fuzzy sorts of tests because the cases are not entirely consistent with the views of the IRS. But generally, we've all gotten comfortable that if you have know-how, if you have a business plan, if you have something, my rule of thumb is, look, if what you have is legally protectable under state law, then I think that meets the definition of property and we'll go with it. And I've not really ever been contested on that. So let's move right along to where this comes up often. So let's suppose that you've started as an LLC for whatever reason. And I have a whole, I mean, in fact, section 1 was on choice of entity. We talked about why you might want to do that, or you might have done that. And then an investor comes along and they say, that's great. I only invest in corporations. You need to incorporate your LLC. So you'll incorporate it. Now, as a corporate matter, that is super easy. We file one little piece of paper with the Secretary of State of Delaware, and poof, your LLC is now a corporation. As a tax matter, about 1 million things happen when you file that one little piece of paper. So let's walk through that in this case. So number one, we're protected by Section 351. We have a transfer of property to a corporation in exchange for stock. So that transaction is tax-free. Why might we want to do this? Well, the investor is going to demand it, but there's lots of other good reasons why you would do this. We're going to talk actually in 2 weeks about mergers and acquisitions, and that's what Section 368 is. It's a tax-free merger. You can do tax-free mergers under this Section 368. That means you trade the stock in your company for stock in, I don't know, IBM or Intel or NVIDIA if you're lucky. And you avoid tax on that transaction, but only corporations can do that transaction. LLCs, taxed as partnerships cannot. So that's another reason why being a corporation is a good idea. A third reason is something we've talked about earlier is LLCs cannot grant incentive stock options. Only corporations can do that. And, go back to the previous slides or previous lectures if you want to hear why ISOs might be a good thing. And then finally, and this is by far the biggest issue in all of this. All of the rest of this is noise compared to this issue. And that's the qualified small business stock exemption. And I've talked about that several times already in the past year, and I'm going to talk more about it today. But this is the idea that your stock, the gains on the sale of your stock up to $15 million or 10 times basis can exclude federal income taxation. The gains on that sale can exclude federal income taxation entirely up to those limits if it is qualified small business stock. And stock in a corporation qualifies, interest in an LLC, taxed as a partnership do not. So that's probably the number one reason I see LLCs incorporate. Now let's talk about the incorporation. Remember I said, even though it's a simple matter as a corporate law matter, it's a complex matter as a tax matter. And so there are a couple different ways to do it. In some states, most states, maybe even all by now, there's this thing called a formless conversion. Like I say, we just file a piece of paper. We don't have to actually form a new corporation and then have an assignment of assets or an assignment of LLC interest to that new corporation. We just do what we call formless. We file a certificate of conversion. Well, that's easy as a corporate law matter, but what is happening as a tax matter? And the IRS says, well, it's one of three things, right? Because we live in this theoretical world of tax. And either the corporation, it's either assets up, assets over, or interest over. And I'm not going to spend a lot of time on this, but I'm going to touch on it because there is sometimes a difference. And sometimes it's a big difference, to be honest. So the assets over method, and by the way, we will designate in the documents what it is that we're doing as a tax matter, if it's a well-drafted document that has thought about this issue. And the assets over transaction means the LLC transfers all its assets and liabilities to the new corporation in exchange for stock, and then distributes that stock to the LLC members in liquidation. And this is kind of a list of what the tax consequences are. You can review this at your leisure, but basically no tax. We have a carryover basis and holding period. That's just and what we call a substituted basis, meaning that the LLC members are going to take a basis in their stock. And remember, tax basis, that's your cost of the stock for capital gains. So they'll take a basis in the stock equal to their basis in the membership interest that they used to have. The assets up method means the LLC transfers its assets up to the LLC members, who then transfer it down to the new corporation in exchange for stock. Again, the LLC members we're going to have a substituted basis in the assets. So the LLC members end up taking a basis and holding period in the stock that carries over. So usually this isn't there's no difference. I mean, usually we're pretty close to zero on both counts. Once in a while, you get a big, huge difference between inside and outside basis, and you might get a different result under these different scenarios. And then interests over, which the LLCs transfer their LLC interest to NewCo in exchange for NewCo stock, and then the LLC liquidates, which is treated like an asset transfer to NewCo. So, like I say, usually we don't have to get too balled up in this because we're dealing with time in startup land. By the time this happens, we're dealing with small numbers, but once in a while we're not. The real issue that we're concerned about that comes up in every one of these whenever we incorporate an LLC is the debt issue. So here's the scenario. We have this LLC, and you have a service partner and a money partner, founder and investor, and the service partners put no cash into it, of course, because founders just don't do that. They use other people's money, right? And the investor, let's say he puts $1,000 into the company. Company just burns through that the first year, and they generate a lot of deductions. And they go back to the investor and he gets a big deduction. Well, that's fine. We both got a zero basis now because its basis is the amount of cash you put in less your losses. Well, what happens if that LLC goes out and borrows money now, generates some more deductions? We have to allocate them somewhere. And if we allocate it, and we got two partners now who have zero basis, if we allocate it to them, if they can actually deduct that amount, they're gonna have negative capital accounts. And this is way beyond the scope of what we're doing, but the partnership tax rules do allow someone to deduct those amounts, subject to some limitations. I'm gonna talk about that in a minute. So now we've got debt in excess of our basis. And this is the issue that everybody kind of freaks out about at first. Well, gee, whenever you transfer asset that has debt in excess of basis, you've got recapture. Right? You've taken more deductions. You put in $1,000, but you got $2,000 of deductions. So you have to recapture that. You're going to pick up $1,000 of income, right? Because you've taken deductions you did not pay for. That's the basic idea. And that can happen very subtly because the other way this happens is through what they call debt shifting, because the partnership tax rules, they allocate debt to different members in order that they can claim the deductions. And the debt can just shift and be reallocated to somebody else. And that will be a deemed distribution. And now all of a sudden they've got a recapture event. Well, the reason this in practice does not really turn out to be a gating issue, well, there's two reasons, a tax and a business reason. The tax reason is because there are limitations on, especially for passive investors, on what they can deduct. So when you kind of work your way all the way through to the end of the problem, what you find out is that, yeah, there's debt in excess of basis, but those losses were never claimed. They were all suspended because of all these rules that don't let you take the deduction. So we don't have a problem. And the business reason is we don't see LLCs using debt anymore. They use safes. They do other forms of equity. And as long as the safe is not treated as equity on a company's books, we might have a way around this. So I just want to point out the issue because it always comes up. We always have to do the math, have to do the analysis, but we can usually find a way out of this one. Okay, let's get to kind of the main event here. What I said, the most important reason is because people would want QSBS. We've talked about qualified small business stock several times already during this series, and I'm going to talk about it some more now because we've had some big changes in the law, as you probably know. So what does qualify as small business stock? Remember what I said, we hold this magic stock for 5 years after original issuance at sale by the corporation to us, or we got it in exchange for property, or we got it when we exercised an option, or we got it for cash. We hold it for 5 years, at least 5 years. We get to exclude up to $15 million worth of gain. It used to be 10 million, but as of July of this year, stock issued after July, it is now 15 million. We can exclude that amount from income when we sell the stock. So original issue, 5-year holding period, up to 100% exclusion. The business has to be a qualified small business. That means it has to have less than 75 million of gross assets. It used to be 50 million. After July, it's 75 million. It has to meet an active business test. So these last two are kind of sleepers. And I want to pause on them for a second because everybody just assumes they're going to meet this active business test. And if you look at the IRS guidance on this, it's all over the place. Most companies, it's pretty clear, but what they're trying to do is to keep people like me from being able to sell qualified small business stock. If you're a consulting company, a professional services company, you should not be able to sell this. This is designed to incentivize companies that actually make something. And apparently, Congress has deemed me not to be worth incentivizing. But if you're making real products, you're not a consulting company, then you're probably within this. But it gets a little fuzzy sometimes when we see things like marketing services, So that's the active business test. And sometimes we have to drill down on that and think a little bit about it and maybe hold our nose and take some risk. And then significant redemptions, which I'll show you in a second. I did want to mention that the One Big Beautiful Bill Act has made this exemption way more liberal, which I find kind of interesting because I don't know who's up on Capitol Hill lobbying for this, but it just keeps getting better and better. The Biden plan had proposed scaling this back, and what we got under the current administration is expanding it. And the expansion is, number one, it used to be you had to wait 5 years. It was all or nothing. If you sold your stock after holding it for 4 years and 11 months, which I have seen happen, by the way, you did not get the benefit of this exemption at all. 20% federal tax. The idea now is that you kind of ease into it. You phase into it over 3, 4, and 5 years as to what the amount of the exemption is that you get for QSBS acquired after July 4. So the old QSBS, you still got the 5-year rule with it. The other expansion, as I mentioned, we changed the asset threshold from 50 to 75 million, and we're going to get inflation adjustments in another couple of years. All right. And the gain exclusion, 10 million it used to be, and now it's 15 million.
Wow.
So let me move on to, okay, let's move on to, I was just talking about LLC conversions. Remember I said this is one of the reasons you would do this. So a couple of things to note about this is that when we do, and for any property, whenever we contribute property to a company, but especially with an LLC, it's a relatively, it's a decision point. Let me put it that way, because you are trading, you might want to wait because you're going to get 10 times, up to 10 times or $15 million, right? And it's the greater of your exemption when you sell. And 10 times what? Well, 10 times the cash you put in, plus the property you put in. So, but what you're trading, so the longer you wait and the more the property appreciates, the more the potential exclusion. But the trade-off is that appreciation in the property, that value at the time you contributed, is not going to be QSBS gain. And on the back end, when you sell, you're going to pay tax on the appreciation that was there at the time of contribution, but exclude the future appreciation up to the QSBS limits. And then the second thing about LLC conversions to note is just this threshold. We don't want to go over that. We need to convert before we hit that threshold or we lose the benefit. Or Yeah, right sizing might be a little beyond. I mean, there's ways to plan into making sure we stay under that 50-75 million dollar value. And similarly with S corporations, we talked about S corporations early on. If you're unfortunate enough to have an S corporation, that does not qualify. That cannot issue QSBS. However, it could convert to a C, and then the stock issued after that conversion, not to you, the founder, but to the investor after the conversion, does qualify. And there actually are some structures that you can use to get you out of this problem. But they're complicated, they're involved, they're expensive. I talk a lot about them. I don't often do them after people understand all the hoops they have to jump through to get there, but you can get there. I'll just leave it at that. Now, I want to mention a couple other things about this. Because if you're a startup, you're going to be thinking about QSBS, and you might as well know that these strategies are out there, even though they apply at the individual level, not at the corporate level. And number one is leveraging. So one of the interesting features about qualified small business stock is that I basically can gift my attributes to somebody else. So if I own qualified small business stock that I paid $1,000 for, and I want to give that to my daughter, I can make a gift to her, and now she has QSBS with $1,000 basis in it. And she just basically steps into my shoes with respect to that stock. Well, you know what? If I give it to two people, well, they each have whatever my basis was in the stock, but they each have a $15 million exemption, or 10 million if I acquired it early. So think about that for a minute. We could multiply the exemption. And that's exactly what people do through trusts. And you'll see people take this out to just extreme levels because there is quite a loophole in the statute. So when you hear about leveraging and you hear about trust planning, that's what people are talking about. They're taking a stock, they're gifting it to a trust that has a lot of beneficiaries, and thereby multiplying the exemption. Congress had an opportunity to fix that, but they declined to do so. The other thing I want to mention, because I get this question constantly, gee, is my safe qualify for QSBS? And does it qualify as of the date of issuance? And we've talked about this before. Pretty much everybody in the Valley will take that position. The accountants that have to sign the returns, because I don't have to, the accountants who sign the returns will do that. Everyone I've ever met without much question and without agonizing it over very much. Although I will tell you, it is an unresolved question. The IRS has not weighed in on it. And honestly, I think if we were being intellectually honest, I think the case for the post-money safe is much stronger than the case for the pre-money safe in terms of being stocked for QSBS purposes. I will tell you that options and warrants quite clearly are not. So a warrant is not the same as a safe in this context. And then finally, the other sneaky issue here I want to warn you about is this idea about significant redemptions. So here's the point, is that QSBS is supposed to be issued by the company originally. I mean, you buy it from the company. We're trying to incentivize investors putting money into the company so the company can go hire a lot of people and employ people who will vote for the people that enacted QSBS, right? There's no benefit if somebody buys that stock from another investor. Congress was not trying to incentivize a rich person getting richer. They're trying to incentivize startup companies getting money to spend on development in the United States. So how could we get around that? Well, you don't have to be very creative to say, well, I'll tell you what, how about I put the money in the company and then the company redeems the founder. And that way I didn't buy it from the founder, I bought it from the company. And Congress said, yeah, nice try, but we're not going to let you do that. If you have these prohibited redemptions within a certain amount of time of a sale of stock or an original issuance, then that sale is not going to qualify. In fact, no sales around during a certain period of time will. So we have to be super careful about that because this comes up in secondary sales. And secondaries are super common now. It's almost never that I do a financing, at least at Series B and above, where we don't do a secondary. And so we have to run the gauntlet, make sure we're not violating these rules. And maybe we are. Maybe we just bite the bullet and say, look, sorry, founder, or sorry, investor, you're not going to get QSBS treatment on this because of the significant redemption rules. And it's not only QS, this is a good segue, because it's not only that the stock sold to the investor is not QSBS if that company turns around and redeems that stock from founder, but it's also that the founder has to sit and worry about whether they've got compensation. Because let's think about it. Let's say that the founder has common stock that's worth $1 a share, but your preferred stock is selling at $5. And the investor comes along and they put money in the company, and then the company buys the common stock from the founder that's worth $1, but they pay him $5 for it because the investor bought preferred, and we're trying to give that premium to the founder. Well, that sounds a lot like compensation. You're buying property from an employee for more than what it's worth. Now, there are ways to deal with that, but it's an issue that has to be considered in every secondary sale. It's a much different result, by the way, if it's a completely, totally unrelated investor, unrelated to the company, that comes in and buys the stock from founder at $5 a share when it's only worth $1, and then that stock converts to preferred later. That's a different scenario than if the company buys it from founder, which you might consider to be a triumph of form over substance, but welcome to tax land. And then finally, don't forget about 1045 rollovers. So let's suppose we've got our QSBS, but we didn't meet any of the holding periods and we're being forced to exit because the time's right. And I'm a minority shareholder. I can't stop it from happening. Company's being sold. I haven't met the holding periods. I don't get to exclude the gain. Well, you know what? If it was QSBS otherwise, and we've held it for more than 6 months, we got 60 days to reinvest in another qualified small business, make this special election, and not pay tax. We've rolled the gain over into a new corporation. You can get super creative with this, by the way, and there are a lot of people who would just go form new corporations to park funds in and claim that the stock in the new corporation is rollover stock. Be careful with that strategy. I've seen it used many times. It is highly fact intensive, and the company has to really be an operating company that you're investing in. Can't just be an incorporated pocketbook. Okay, I mentioned compensation, so let's kind of pick up on that because that is sort of the second or third big issue with startups, is because the Silicon Valley was really built on sweat equity. Well, what is sweat equity? That's the idea that you're working, for your value that you're building. And typically when you get paid for your services, that's taxed as ordinary income. That's compensation. So we really have to be sensitive that whatever we're getting is not going to be taxed as compensation because that is the highest rate of tax. We'd rather have it taxed at capital gains, or better yet, at 0 QSBS. So how does this come up? So IRC section 83, this is the one that we have to look at first. It says whenever property is transferred for services, the recipient includes in gross income the fair market value of the property at the first time is transferable or no longer subject to a substantial risk of forfeiture, which is another way of saying vested, right? So think of your typical transaction. We have a founder in a company, they buy stock in a company, the stock is unvested, right? And that means that it is subject to a substantial risk of forfeiture. They could lose it if they leave employment. That's substantial. So it's unvested. And the general rule will be that when that stock vests, we have to compare the value of that stock at the time of vesting to what they paid. So the founder paid a penny a share at most. And the stock was worth that when he got it. But a year later, when it vests, it's now worth $1 a share. Well, under this rule, at the date of vesting, they've just made 99 cents a share, right? Because they got $1's worth of stock deemed to have happened at the date of vesting, because that's when it's no longer subject to forfeiture, over the 1 cent they paid. Well, that's not a super good result, is it? So that's why the IRS allows you to make a special election to say, look, we're just going to agree and pretend that the stock is not subject to a risk of forfeiture. And I, Mr. Taxpayer, will take into income the difference between the value of the stock and its value as of the date I received it. Not that later date when it vests, but as of today. And in startup land, that number is always zero. The spread is always zero. It's worth a cent when I bought it, and I paid a cent for it. That's the 83B election. And then now we closed the compensation element, and any future appreciation, and we sell it later, that's going to be all capital gains or QSBS. The IRS now allows you to file a form. You can do it on your own form, but there is an IRS approved form if you want to use their forms. But you do have to make the election within 30 days. Everybody probably knows this. By the way, this is startup tax, but I will tell you, you get a much different analysis when you're outside of startup land, because then you're dealing with stock that really is worth something. And people would put vesting restrictions in and not make an 83B election because they don't want the income now. They'd rather have it later, even though it's going to be ordinary and even though it's going to be larger, maybe. Employer gets a deduction for any amount that the employee, my clients, startups, they don't care about deductions, but you ought to know that it's there. And, this came into law a few years ago, and it was maybe, I think it's 2017. Anyway, Section 83I was another special exemption that allowed employees to defer income up after the stock vests if you meet certain requirements, and we all kind of built it into our stock option plans. But in all the time it's been in the law, I've never, ever, ever seen anybody actually use it. So, but it is there, so I got to mention it. And that's all I'm going to say about it. There is an election to defer income after vesting if the company meets certain requirements. And the reason we don't is because then you have to apply to everybody, and the monitoring is kind of nightmarish. It was a nice try at Congress, but it didn't really help. Let's move right along to Section 409A, which everybody now knows about. It's kind of the bane of our existence if you're a Silicon Valley tax lawyer or a corporate lawyer. And 409A is the idea that if income is earned, compensation is earned in 1 year and paid in a later year, well, that's deferred compensation, and it either gets taxed in the year earned or it has to meet these various requirements under 409A. And we could spend forever talking about the history of this and Enron and World.com, et cetera, and all the abuses that gave rise to this. But I think it's more useful to talk about 409A. So here's what it is. That's what it does if you earn it now. So if you have deferred comp, you're going to get taxed today unless you meet these requirements. That means a written plan. It means the payments have to be paid within a set time frame or time window based on some very specific permissible payment events. The form of payment, the time of payment have to be specified, and an election has to be done prior to your vesting of this amount. And then it gets super more complicated after that. And sometimes in tax, you just have, it's very cookbook. I mean, most of the time it's economics, etc. Sometimes the rules are very cookbook, and these rules are very cookbook. You just have to sit down. I remember when the 409A statute is very small. The 409A regulations are about this high. And when they came out, I remember I just sat down and poured myself a glass of scotch and wasted a day or two just reading them, because that's what you have to do, because they are real gotchas. And because of that, most of the time, my startup company clients, rather than complying with 409A, we look for exceptions to it. And the number one exception is what they call the short-term deferral exception, which typically means you're going to pay by within 2.5 months of the end of the year that the income is earned. And that's the one we rely on almost all the time. Sometimes we can't, so we'll just, go ahead and put the written plan in place that meets all the requirements. But that's the usual exception. Okay, you can defer income, but you got to pay it within 2.5 months of the end of the year. Startup issues, the number one biggest one that comes, well, there's two of them. Number one, options. We've already talked all about that, so I won't belabor it. But an option is a form of deferred compensation as far as the IRS is concerned. It's subject to 409A, but we've created an exception for it as long as the option is granted at fair market value exercise price. We went through all that earlier. The second big place it comes up is, and I see this all the time, founder is working, and one day they say, I've been working a long time with no pay. And, I think I should get paid for all that time I put in, because someday I'm going to get funded and I sure want some of that money. So they'll put in place, they'll see a board resolution. It'll pop up in the board resolutions. We agree to pay the founder, X $100,000, whenever the company has enough money to pay it at some point in the future. Well, we have just created a deferred compensation plan. And remember, it either has to comply with 409A or we have to fit within an exception. And this is factual, so we have to examine exactly what the terms are. And usually we're going to pay that when we close our first financing. Well, you could view that, and I've heard tax lawyers argue this both ways, and I do mean argue. We could say, look, if you don't get the financing, you don't get the money, so it doesn't vest until the financing. And then it's going to get paid within a very short time of the financing, so we fit the short-term deferral exception. The other view is, well, no, we know you're going to get the financing. So on the way the term vested is defined under those stack of regulations, which is different than it's defined under Section 83, by the way, if you read it carefully. So we think it's already vested. So you do have deferred comp, and you've got a violation of 409A because a financing round is not a permissible event. And I am not going to try to answer that question now. All I will say is I just try to avoid issues rather than create them. So if we can just require our guy to be employed at the time of the financing, I think we got a much better case. Second big issue that comes up under 409A is this valuation that I said you had to get to issue options. Remember? Options have to be granted at a fair market value exercise price. Well, what if we formed the company yesterday and we haven't done anything yet and nobody can value it? We went and talked to the valuation people and they said, what am I valuing? There's nothing there. And then I'll hear people say, well, the company's so new, and people used to do this all the time, regularly. It's so new, we're just going to issue the option without a 409A valuation because it cannot be valued. It's super new. And I think that's a dangerous strategy. And these days, instead of that, we'll just do an offer letter that says we will issue an option at some point in the future when we can value the company. And that seems to work because, as we've discussed before, if you never get to that point where you can value the company, none of this matters anyway. And if you do get to that point, well, then you've got your guaranteed right to get the equity at that point. Okay, moving along to stuff we haven't talked about, Section 382. So let's imagine you've got your typical startup company. It's generated tons and tons of tax losses. It's never made money, and it should not, by the way, because what you want to do is build a valuable goodwill asset, not a lot of current income. We've talked a lot about this before. So now we got all these losses. And so an acquirer might look at that and say, gee, I sure could use those losses because I'm a big profitable acquirer and you're a little startup company with all these losses. I think I'm going to buy the companies just to take advantage of the losses. Yeah, Congress says, no. And they said that for at least 50 years. And what happens is those losses get limited. So the buyer can use the losses, but only over a very long period of time. And that's what Section 3 does. It limits the use of, and not just losses, but other tax attributes, but mostly net operating losses and credits. So why am I talking about this now? Because Section 82 kicks in when you've had a change of control. And that can happen inadvertently, right? And it happens inadvertently when a company does a series of financings. And then all of a sudden, and it's over a 3-year period, and all of a sudden you look back and you say, oh, you know what? We've just transferred more than 50 percentage points of the company over 3 years. Our NOLs are now limited to the value of the company at the time of the change times an interest rate in effect. And we didn't know that was coming. We didn't intend it. It means, the buyer is not going to get to use the losses as quickly as they thought. Now, I could go through the math examples, but I'm not going to. I'm just going to tell you that when you do financings, if you're tax sensitive, somebody ought to be paying attention to section 382, probably the accountants, if you have NOLs and if you want to take care of them. So just doesn't come up very often because honestly, buyers don't buy startups to get their losses very often. But if that is the case, this is a tax issue. Okay, I'm going to talk a little bit about misclassification, not a lot, because we've covered this before. I'm in California where we have what we call the Dynamex, I understand it's pronounced, test, where a worker, like every startup would like their workers to be independent contractors. It saves them 30% of payroll costs. You don't have to do withholding. They don't have to do employer portion with payroll taxes. They don't have to do SDI. They don't have to do this goofy thing in California. There's like a mental health tax, I think it's added on payroll. They don't have to do any of that. They don't have to do workers' comp. That's a big number. Unemployment comp, insurance, that's another less big number. So this question, are you an employee or a contractor, is a big one. So how do we know if a worker is an employee or a contractor? Well, in California, unlike many other states like Nevada or Texas, you're an employee unless all of these three tests are satisfied. The worker's free control and direction of the hiring authority. That sort of makes sense. Worker performs work outside the usual course of business, and the worker is engaged in an independently established tax, trade, occupation, or business. I should say, or business of the same nature. Yeah, that second one, that B is what usually messes us up, right? Because how often is it you're going to hire somebody that's doing work that's outside your course of business? If you hire a lawyer, okay, that makes sense because unless you're a law firm. But if you hire a software programmer and you sell software, then the question's a lot closer, isn't it? So that case has been incorporated into law. It's what we now call AB5, and it is such a broad rule. It is such a broad rule that when it was enacted, our state legislature enacted exemptions, and there's close to 100 of them. You might think about the wisdom of a law that has to have 100 exemptions, but that's beyond my pay grade. I will just tell you there's a long list of exemptions from AB5, and anyone who's got a good lobby in the state has an exemption, like professional services. But you can go through them. I won't do that for now. I want to focus on, and I won't talk about app-based drivers because they got their own different regime as a result of a ballot initiative, because the voters took that decision away from our dopey legislature and enacted their own law for app-based drivers, because I still want my Uber and I want my DoorDash. But for everybody else, we got to deal with this law. And the big exemption that we all look for is called the business-to-business exemption. And all of these factors have to be true in order to not be an employee under this business-to-business exemption. And it's a little looser than the general law. But again, we've talked about this more in a prior presentation, and you could, peruse this at your leisure. Just be aware that it exists and you have to comply with it. Wow, I'm not even halfway through my slides, man, but I'm going to keep going. Tech transactions. This is so text heavy. I'm not going to spend too much time with it. There are numerous statutes that deal with the deductibility or capitalization of the cost of developing intellectual property, and are also credits. I want to drill down, and not only IP, but other assets as well. I want to focus in a minute, but let's do it now, on what has happened recently in this space, and on a couple of things that are of particular relevance to tech startups. And number one is Section 174. And the recent tax changes have restored, you could say, because we lost it temporarily, and it kind of drove the accountants nuts because no one could understand what's going to happen in the future. But now this idea that R&D expensing has been restored. So companies used to be they had to capitalize their research and development and then amortize it, meaning that you deduct it over time. And now companies are allowed to immediately, domestic R&D, not foreign, they still have to be capitalized and amortized over 15 years. but domestic R&D costs can be immediately deducted. And small businesses get a break. They can amend their returns to go back. And this does include software development costs. That's big news. Big news in startup tax land, by the way, because companies that are profitable were super concerned about this. They're spending money and not getting a deduction for it. Related to this is the R&D tax credit. And so this has been around for a long time, and it ought to really be called a credit for increases in research and experimentation expenses. So we'll just call it the R&D tax credit, but it's complicated. It's out there, and it really depends on the nature of the research and if it meets these requirements under this 4-part test to be qualified research. And the big news in this space right now is that up until very recently, in order to figure out if you made this test, companies generally had to go hire a bunch of engineers to analyze all this and write it up and say, this is, these are the alternatives, these are uncertainties, this is the improvements, etc. And lately, you're finding people doing all of that with just AI. And this is, if you're thinking about places where AI is going to replace service people, I think this is going to be one of them. Because I have talked to companies now that have said, we're just using AI to write these reports on our R&D credits. So we'll see. What's really important for startup companies, though, is the idea that small businesses early stage businesses, I should say, that haven't had any revenues before and now have some revenues, have some gross receipts, and they're not profitable, so they don't care about credits, they don't care about deductions, but they do have employees, and they heard what I said about Dynamics and Borello and AB5, and so they've got them on payroll and they're paying payroll taxes. Well, they can take their R&D credit against their payroll taxes. So there you go. A huge benefit for startup companies. So even a company with no income and no income tax can get a benefit from R&D credit. So it's worth paying attention to. Let me jump ahead to a couple other things. 482 reallocates income among controlled corporations. This is really honestly only going to be relevant to you, or usually I should say relevant to you, if you have a foreign affiliate, foreign parent, US sub, or vice versa, and you're doing some sort of transactions between the two, or you're transferring IP from one to the other, which we will do in reorganizations, but there is an arm's length standard. And it comes up once in a while with startups, very often with larger companies. But the idea is that the transactions between the companies have to be at arm's length because we don't want to be playing games where we're putting income in a tax haven when it's really being earned in the US by siphoning it out through excessive fees or royalties or something like that. So be aware there is an entire body of law around this, and there are huge penalties if you get this wrong. And the regulations are very detailed and specific as to how to get it right. And in a prior life, I've written 482 studies, so I can tell you that it is something. 305, I taught an entire semester course on this up at Golden Gate, so I'm not going to do that in the 4 minutes we have left. I will tell you that this, at a high level, it goes to the abuse where we have what looks like a redemption, which could be QSBS or capital gains, which is really a dividend. So just imagine a scenario where we've got a corporation, it's got income, it's profitable. We don't think much about it in startup land because it really only applies if you've got companies that have earnings and profits. And if you've done things right, your company should not have taxable earnings and profits. But let's say you do. And you want to get those EAP out to the shareholders, but you don't want them to you don't get a deduction as a startup when you pay a dividend, and the shareholder has to pick it up into income, albeit at a lower rate. On the other hand, if it came out as a redemption, well, they could get capital gains rates, they could offset their basis, they might get QSBS treatment. So it's way better for the shareholder to get that money out as a redemption rather than a dividend. So let's say I own 100% of the stock and I say, hey, company, instead of paying me a dividend, I'm going to have you redeem some of my stock. So I have 100% before, I have 100% off after, but even though I got fewer number of shares, well, that's what this is designed for, to cure that abuse. And it's been around forever. So this is nothing new. Why I'm talking about it here is because it will come up in the startup scenario in some very subtle cases that you might not expect, like when ownership proportionate interests change. And where this happens a lot is when we have convertibles that have different conversion rates. And it's not very often that we have to think about this because, like I say, if you don't have E&P, not an issue. But when it does, we do have to run through the gauntlet of these regulations and make sure that when we're doing our recaps or our financings or issuing our convertibles, that we're not in effect shifting E&P from one shareholder to another. And there's an example of some scenarios where this could happen in a startup scenario, but I'm not going to go through them now. You can visit them in my slides. Capital gains we've talked about. Safes we've talked about. I just want to close with the last thing that happened that's been amended recently. So the Qualified Opportunity Zone program, you might remember, was created under Tax Cuts and Jobs Act of 2017. And the idea is that we're going to incentivize investors to put money into economically distressed communities. And you'd be maybe a little surprised as what qualifies as economically distressed, but that's a different issue. They're designated low-income census tracts, and each state will actually designate these zones or nominate them, and then the Treasury certifies them. And we have oodles of them across the United States. So if an investor invested in that, they can defer taxes on prior capital gains, so they can roll over their gain from, like, a sale of stock, we'll say, because they've reinvested in a qualified opportunity fund, and they can reduce. For earlier investors, it used to be they could reduce their deferred gains, but even now we can exclude future gains. So what I want to mention about this, without getting it, I said some of this stuff is cookbook. This is like super cookbook, so I'm not going to go through it. But what I want to mention is that this program was set to expire after December 31, 2026, and now it's indefinitely extended. So it's kind of taken on a new life. And there are some additional new incentives for rural investment. So a 30% basis step up in some rural designated qualified opportunity zones, and the scope has broadened to include more types of projects. So just keep in mind that the QOZ program, it didn't go away, it's gotten bigger, so which happens in tax quite often. Okay, we're a minute over. Sorry we got started late and I had to kind of skim over some parts, but I am going to make this recording publicly available. I will email the slides to whoever wants them. Just send me an email. And in fact, I'm going to go ahead and stop. Well, I'm Roger Royce. I'm a partner with Haynes Boone in Palo Alto. I do emerging growth and venture capital. I'm also the author of 2 books. One is Dead on Arrival: How to Avoid the Legal Mistakes That Could Kill Your Startup. By the way, on this book, my daughter called me about a week ago, sitting in my office, and she said, "Turn to page 67 of your book." And I did. And she said, "What?" And I said, "There's a typo." I said, "There is not a typo. This book's been in print for 12 years. I've read it over and over. Lots of people have read it. There's no way there's a typo." She said, "There's a typo." And there was. And one of my graphics, a letter got cut off. And she said, "This is proof that no one has ever read this book except me." So I hope that's not true. The second one is 10,000 Startups, Legal Strategies for Startup Success, which is the flip side of my prior one. So
Hey,
with that,
Roger. Thanks very much, Roger. This was great. I feel personally exposed in a couple of areas of things you talked about today.
well, maybe we can help you with that, Bob.
Have we terminated the call?
Not yet.